Good morning, and a warm welcome to this conference organized by Gorrissen Federspiel and Tænketanken Europa on the rule of law. And a warm welcome also to those of us following us online. So a warm welcome. Today, it's almost 32 years ago on this very day that the Berlin Wall came down. And I won't start this sort of conference relaunching the overall debate about whether Francis Fukuyama was right when he wrote his essay, End of History, or what he actually meant. Neither will I get into a long debate about from Copenhagen to Copenhagen, so talking about the membership criteria agreed upon in this very city back in 1993 to the closing of accession talks in 2002 with Central and Eastern European countries, just a few stops on the metros away from here. But I think it's pretty safe to argue that none of us, even a decade ago, would have thought that we would host a conference with the following backdrop. And here I'm just referring to events that have taken place in the last 2 weeks. Judge number 8 in Poland has been suspended for asking preliminary questions to the European Court of Justice. The European Parliament has submitted a lawsuit against the European Commission for its failure to apply the conditionality mechanism to the Court of Justice. The European Court of Justice has ordered Poland to pay a fine of €1 million per day over its decision to ignore an EU ruling on Warsaw's judicial reforms. The United States of America has decided to exclude one EU member from its Summit of Democracy, being Hungary. And a few days ago, the President of the European Court of Justice, in light of the recent challenges and developments in the speech in Hague, said that, I quote, the survival of the EU in its current form is at stake. So what we'll discuss today are these issues, and as the title of the conference indicates, basically, are we witnessing an erosion of the EU's very foundation, the rule of law, and especially also how does this affect European, including Danish companies that operate in countries where rule of law is under pressure. And to do this, we have an excellent panel. And just to be sure, the aim here is to get an overview of how these specialists look upon the situation about rule of law. If one misses a Central European perspective, I can say that we at Tænketanken Europa hosted the Polish Minister of Foreign Affairs couple of, well, actually last year, and I'm sure that we'll also host a number of other speakers from Hungary and Poland at a later stage. What I'll do is that I'll introduce our panel as we go along. And the first one is Professor John Ryan, Professor of Law and Politics and International Relations at the University of Groningen. I've been trying to say whether I could pronounce it like that. You have also worked as a civil servant. As a matter of fact, from 2009 to 2019, you worked on EU rule of law related files in The Hague and Brussels, also the Dutch civil servant and diplomat. This July, together with 2 other scholars, you wrote a report at the request of the Green Group in the European Parliament on Hungary and the rule of law mechanism. And I remember the very day it came out, I decided to write you an email to see whether I could persuade you to come here today. And thank God you said yes. So now the floor is yours, and thank you very much for coming, John.
Perfect. Many thanks, and many thanks for inviting me. My name is John, and it's really a pleasure to be here. It's my first time in Denmark, if you can believe that. It's not my first time with Danes, I should say. I worked, as was said, as a diplomat in the Dutch permanent representation, but also as a national liaison officer of the Netherlands for the Fundamental Rights Agency. And what I realized that what the Dutch share with our cool cousins, the Danes, is a sense of humor, but also a real bond in being among the frugal four. And of course that we are actually champions of the rule of law. And I think that that is what we'll be talking about today. What I want to talk to you about in the next 20 minutes is first give you a bit of an outline of where we stand with the rule of law situation. Luca was already telling you a little bit about that. It's not a good sight, but I want to give you a bit of a general overview of that. Then I want to zoom in on the newest kid on the block with regard to the rule of law tools, the rule of law conditionality regulation that entered into force this January. And almost 11 months ago in Brussels, there was a very heated debate about what that deal should look like. And then I want to tell you a little bit about the applicability of that tool to specifically Hungary, because that's what I did some research on. I should say that perhaps it's a bit awkward to talk about the rule of law conditionality mechanism at this point in time, because what the hottest debate in Brussels is at the moment with regard to cash and the rule of law is not actually the rule of law conditionality regulated, but whether or not COVID money, specifically earmarked money for COVID funds, should be released to Poland and Hungary. The Commission has blocked that so far. And that has very much to do with rule of law issues, both in Poland and Hungary as well. I know that this is a general audience, both here in this beautiful venue and online, so I'll try to keep it as non-technical as possible. If you have any questions or clarification, please ask them immediately, or I'll be happy to answer them later. Now, let me start. I know it's a Monday morning. Let me start with a fun slide. We often talk about the toolbox of the rule of law in the European Union. And of course, you have different tools for different problems. But if you actually use tools, your tool set would look something like this. It looks like tools that are often used. It looks like a diligent worker who actually is happy to use them. And they're different in nature. You have political tools, you have policy tools, you have legal tools. And legal tools in the context of the rule of law in the EU setting. You can think about infringement actions. The Commission can sue a member state for violating EU law. Member states can sue each other for violating EU law. EU institutions can sue each other. So there's plenty of different tools for different problems. Now I'll also give you the tool set and the live footage of that for the European Commission's tool set. You see here that it is somehow a little bit clinical. You see that there's a sense that very little is done, that it looks like there's beautiful tools, but they're not often used. And all we actually, in fact, talk about a lot in the EU setting is creating ever more tools rather than using the existing ones. And that is particularly dramatic if the situation with regard to the rule of law in the EU looks something like this. This is the live footage of the rule of law situation in the EU setting at the moment. So there's, I should say that I'm criticizing with this slide EU institutions that are political institutions, the Commission, the Council in particular, and to some extent the Parliament. But definitely not the European Court of Justice that has issued a number of extremely important rulings, both with regard to Poland and Hungary, but also, for example, with regard to Portugal and some other member states. So it's definitely not a criticism of the European Court of Justice. So the vacuum and where we see this huge problem with regard to the rule of law is that we have this beautiful tool set, but we still have a house looking like this. And why is this so problematic, and why did I become passionate about this? It's actually almost 2 years ago that I was in a courtroom in Poland looking at this. This is a court case against a professor of constitutional law in Poland called Wojciech Sadurski. He was actually my own professor at the European University Institute in Florence. And he got into hot water with the Polish government because he had published a couple of very critical tweets after the mayor of Gdansk, a city in the north of Poland, was killed. And what happened was that Wojciech Sadurski, who actually told me a lot personally about liberal democracy, tweeted that it would be you would not be a serious intellectual if you would still give interviews to public TV in Poland, because that has been completely captured by the Polish government. And he also very strongly criticized the current leading political party in Poland, Law and Justice, and called them an organized criminal gang. So very strong language. What happened was that he was actually sued by both the TV channel in a libel case, both in the criminal and in the civil setting, and he was sued personally by the leader of Law and Justice, Kaczynski. And this is what I saw in that courtroom that day in November 2019. I saw a professor that used to face me teaching about liberal democracy facing a judge, and that judge, even if she would be independent, and she proved to be independent, she ruled in his favor, was going to be under huge pressure because there was police in the courtroom. You see a setting of intimidation. This is actually pictures that I took myself. A very small courtroom. The venue was changed at the very last minute, so that as few of his supporters as possible could actually participate. So this is the day that I sort of lost my innocence, and I realized that not speaking out and being expecting others to do the talking for the EU rule of law is not a neutral thing. And I also want to drop a footnote here. I'll evidently get a question later on whether the rule of law is a Western European concept. And that's often something that is brought up in this context. Well, as I said, this Polish professor actually taught me most of what I know about liberal democracy. It's a pan-European concept, and that's important to realize that there's still a lot to learn from not only Polish professors, but also other Polish professionals, because I have some more live footage of the situation with regard to the rule of law in Poland. In the middle, you see Paweł Jusicin, who is the first ever judge who got suspended for applying EU law. He has been suspended by the disciplinary chamber of the Polish Supreme Court almost 14 months ago now for simply referring to some case law of the European Court of Justice. On the upper right, you see Igor Tuleya, who is perhaps the most famous dissident judge in Poland, sort of the spokesperson of the Judicial, the Association of Judges, who has been suspended as well by this disciplinary chamber, where the European Court of Justice said this is not actually a court, so whatever it said was legally null and void. And on the upper right, on upper left, you see a picture that I took 4 weeks ago when I was actually myself in Warsaw. It's a picture of the Constitutional Tribunal that ruled a couple of weeks ago about that primacy does not apply in the Polish context. And what you see here is a building that is completely barricaded off. You see police, and you see that police harassing international press, taking some shots there. But on the lower left, you see some pictures that I took during the demonstration that I participated in. And you see that many Polish EU citizens, a wide majority in fact, is very strongly in favor of remaining within the European Union. So this is the sort of the difficulty that we have now. We have Polish citizens who in great majority want to stay within the EU, and we have Polish citizens, and we have a Polish government that violates in all sorts of ways basic values of the rule of law. Now, I worked, and Luca already said that, for a long time in Brussels, and I realized that if you want to make a difference in Brussels, you always have to go through the law. It's eventually a community of law. So when I was asked, together with 2 other professors, to write a report on how a new instrument on the rule of law, conditionality, and how the rule of law is linked to the budget could be applied, I jumped at that chance, simply because I realized that if you are able to provide how a tool that is in existence not only can, but also should be applied in practice, you are likely to put something in motion in the EU setting. And that is what I'm going to talk about now, and that is the rule of law conditionality regulation. So the rule of law conditionality regulation was actually proposed by the previous European Commission, by Patriot Frans Timmermans, who said that one of the best tools to add to the whole toolbox that we already have is this notion that you only get cash if you comply with the rule of law, and therefore also that EU funding, and we're talking about billions a year, you should only be released if you have a track record of complying with that. That became a very hot potato for about 2.5 years, and last December a political deal was reached that this entered into force. But that deal had some clause that makes its direct application a little bit complex. I'll talk about that a little bit later. But what I want to talk you through is simply the logic of how this instrument works, what is its basis. And the key point here is that really nothing prevents its immediate application, particularly with Hungary. There's overwhelming evidence for this to be applied immediately. So the bottleneck is not the tools or the legal context, but it's really the political will. And what I'm going to talk you through is in some detail, simply to show you the logic of this instrument, because in fact it's not a rule of law instrument, it's a budgetary protection instrument. And that's very important, and even for rule of law warriors like myself, sometimes confusing. But this is simply a tool that helps protect the EU budget in a better way. And the key passage is actually not in the body of the text, but in one of the initial paragraphs. But it's a very important key consideration. It says that sound financial management, that's basically just the principles under which you can spend any EU money, economy, efficiency, etc., can only be ensured by member states if public authorities comply with a number of rule of law requirements. For example, that public authorities comply with the law, that there's independent institutions that investigate whether money is properly spent, and if there's also independent judges where you can go and turn to if there turns out to be a problem. This seems completely self-evident to us, evidently, but this, of course, is explosive given the current situation with regard to the rule of law. But the angle is very specifically, the legal basis for this is really just the legal basis for how you lay down the budget of the European Union. So the angle from which you get to this problem is sound financial management. Now, how is this linked to the rule of law? And actually, this is a very special instrument because it's the first time that the rule of law is actually defined in a specific way with regard to a specific context. Normally, we only talk about the rule of law as sort of a general principle that is laid down in Article 2 of the EU treaties. And there's sort of 6 elements: legality, legal certainty, prohibition of arbitrariness, effective judicial protection, separation of powers, and equality before the law. But this instrument sort of picks from that general concept specific elements that are relevant for sound financial management. It sort of makes a selection from within the broader concept of the rule of law. Say, well, these specific subset of elements are specifically important to sound financial management. These are listed here in Article 3. They are independence of the judiciary. So if you endanger the independence of the judiciary, you also endanger sound financial management. They are about law enforcement and public authorities investigating any misspending and perhaps corrupt practices. And they also are about access to justice. If there is a problem, that you should have an effective remedy to address these elements. Now, this is, I'm telling you openly, this is an instrument that was eventually under the German presidency negotiated in a bit of a rush. So it's a bit of a mess legally. It's a bit all over the place that these elements don't sort of logically follow the flow of money into a country. Normally, if Brussels, let's say, would write a check to Hungary or Poland, you would first look into how this money is managed. Then you would figure out, okay, if this money is mismanaged, is there proper public prosecution of this. And even only at that stage, if something goes wrong, he would have to end up in court, and you would have to have an independent judge. We see that this chronology is not actually listed in this chronological way in the instrument itself. It becomes worse because in a further article, you see that there's even more specific scenarios mentioned, 8 scenarios in fact, where specific elements of the rule of law are listed that are relevant here. Also, independence of the judiciary, effective prosecution of when money is misspent, but also, for example, cooperation with the European public prosecutor, which Hungary is in fact not a member of, and we know why. So a very important footnote here as well is that if you read the newspaper, you will also hear about problems with LGBTI rights protection in Poland and Hungary, and freedom of the media. The rule of law conditionality mechanism has no effect on that, because these things are not in any way related to the sound financial management of the EU budget. So you will have to find other tools in this beautiful clinical toolbox of the Commission to address these, but this tool is not going to help you with that. Now, how do you, when do you actually know that a rule of law problem is so big that it affects the way that you spend EU money? That is laid out in Article 4, which says that appropriate measures, basically sanctions, shall be taken where it is established in accordance with the procedure that I'll talk about in a minute, that breaches of the rule of law principles by a member state affect or seriously risk affecting the sound financial management in a sufficiently direct way. So the key issue here is the wording seriously risk affecting. So this means that it is the nature of this instrument is preventative. It's not that you first have to have a problem and then only later you intervene. If there's a track record of behavior in the member state that risks, makes it very likely that money will be misspent in the future, you already have a possibility under this instrument to intervene. So that is, it's preventative, and that's why it is a crucial addition to all the other tools that were mainly reactive in the EU budgetary field. Some rule of law warriors were quite worried with the wording and that sufficient that it needs to be effective in a sufficiently direct way. I personally think that this is really not that much of a limitation in practice. Why is that? Because, for example, if there's a problem with judicial independence, it's extremely unlikely in practice that a judge will be sort of fully impartial and independent on a part-time basis, only in cases when there's EU money involved. And in all the purely national settings, he will be under the influence, or he or she will be under the influence of authorities. So I think that in practice, this wording that it needs to be a connection in a sufficiently direct way doesn't really limit the reach of this instrument very much. So what will happen if such a connection is found is that the Commission can actually send a written notification to a member state, and this is the thing that I've written for the European Parliament with regard to Hungary. And then there's a quite strict procedure that a member state has to react within a short period of time, and then eventually it will end up in the council, where a qualified majority of council members, which is quite a steep hurdle, in fact, needs to agree that this instrument can really be applied to that member state under consideration. And after that, it's 100% sure that a member state will go to court and try and challenge the decision that was made by the council. So this is the logic of this instrument, and I'm going to talk, and that's the last bit of my talk, specifically about applicability to Hungary. So we did a study for the European Parliament for Daniel Freund, you'll see him on the left, But he managed to convince the whole negotiation team of the European Parliament, you see them in the middle, so that's also the European People's Party, the Socialists and Democrats, as well as the liberal politicians of Renew, to present this report together. And this report urges the European Commission to trigger this new instrument immediately with regard to Hungary. And the legal case for that is the following. You see that on the following slide. The legal case is based on all aspects of the rule of law conditionality regulation. In fact, in Hungary, problems are so big with regard to both transparent management of EU funds as well as national prosecution of any fraud cases, and with independent judiciary, and that each of these grounds separately would already justify triggering it. And in Hungary, we found, based on open sources, just like the Commission should use reports, for example, by international organizations, that there's all sorts of problems that actually justify immediate triggering it. So what are then the problems in Hungary, for example, with the transparency of the management of EU funds? I'll just give you a few examples, and the full report is available on the website of Daniel Freund, and I'm sure that the organizers can also send a link later on. For example, in Hungary, 50% of all public tenders only had a single bid. I mean, imagine that that would happen in Denmark. 10 businessmen between 2010 and 2018, 10 businessmen accumulated 6.5 billion euros of EU money in the way that they applied for this funding. In 2019 and 2020, companies close to the government won about 25% of all the contracts. We're talking about a lot of EU funding here. And financial irregularities with EU funds in Hungary are about at 4% of all EU funds. The EU average is about 0.3%. So you see that, and this flows directly from Olaf. So in this way, the Hungarian government has a track record of just stealing a lot of money. I cannot put it in a different way from the Hungarian EU citizens. There's 4% of all EU funds that do not actually end up where it belongs, namely to the benefit of Hungarian EU citizens. So this shows, for the first pillar, there's huge problems with the transparency of the management of EU funds in Hungary. That would itself not be such a problem if you had effective national prosecution there, of course. Well, there's almost no prosecution whatsoever in Hungary for irregularities with spending of EU funds. Part of the reason is that the prosecutor general is a very close friend of the Fidesz regime and has actually been appointed by them. So where there's a huge problem with the mismanagement of funding, there's a huge lack of prosecution. And then the third aspect then is that, imagine that you're upset about this in Hungary as a Hungarian EU citizen, you would want to go to court. Then you face that there's a huge problem with judicial independence in Hungary as well. That's already, in fact, a lot of people forget that. One of the first things that the Orban regime did was to fire everybody over a certain age in courts. So also there we see a lot of problems. That's definitely not only in Poland. And on the 23rd of November, in fact, the European Court of Justice will make a very principled ruling about judicial independence in Hungary. That was recently, just the other day, announced by the President of the European Court of Justice. Very last slide. What is then the state of play? In fact, Hungary and Poland challenged the legality of this instrument on the 11th and the 12th of October in Luxembourg. I was there, I was in court. But the reality is that there's unnecessary inaction when a piece of legislation is adopted. whether or not you challenge it has no suspensory effect. It could have been applied immediately by the European Commission. It was an interesting hearing because there were 10 member states that intervened on the side of the European Parliament and the Council as co-legislators. Denmark was amongst those member states who defended the legality together with the Benelux countries, but importantly also for the first time major EU member states like Germany, France, and Spain. On the 2nd of December, there will be an opinion of the General, and the latest rumors are that there will be a court ruling I will bet a very good bottle of wine, a court ruling that actually says that this instrument is legal, probably in the beginning of January. So that will then be the green light for the European Commission to really start using this instrument. In the meantime, and Luca was already mentioning that the European Parliament got impatient and has sued the European Commission for failure to act under Article 265 of the EU Treaty. And that action will no longer be necessary if the European Commission, after that ruling, simply starts applying it immediately. And as I said in the beginning, this whole debate is also very much linked to what is hot and happening now in Brussels, namely that large sums of specific COVID money are not yet released by the Commission to both Hungary and Poland that have had recommendations on the European semester that directly relate to their not complying with the rule of law. So I end where I began with political will, and I think that it's hugely important for my own country, but also Denmark, to not expect others to speak up. But even if you're a bit lonely, it's really important to act and think a little bit about that picture that I showed of this professor standing trial in Poland, because that's the reality of the situation. And otherwise, the outset is already hugely under pressure and may actually collapse, and that will definitely not be in our joint interest. So thanks very much. I'm happy to take any questions later.
Excellent. We'll definitely put the paper on our website. I'm not sure that I dare to take up that sort of bet about the good bottle of wine. I'm pretty sure that, well, I hope you win it actually, sort of that bet. We move on now to Professor Marlene Witt from the University of Copenhagen. Just like John, you have your PhD from the University of Florence. You have written many books, many articles on rule of law. Your topic will more sort of be where John ended, sort of what can be done about this, what is the political will that we're looking into here. That's your topic. So the floor is yours. Thank you very much for coming.
Woo. Wow. Thank you very much, and thank you not least to Lykke and the think tank for inviting me to come here today and speak a little bit about one of my passions, big passions, I would say. I really like your conception, rule of law warriors. I think that's a wonderful term. I certainly consider myself to be one of those, and we are also both part of a big network in Europe with professors fighting for the rule of law, the Good Lobby Profs, it's called, with a lot of prominent and very active law professors in particular who are intervening in cases and writing the commission and petitioning all kinds of events and helping judges in Central and Eastern Europe who are targeted by their government. So as Lykke said, I'm going to broaden the perspective a little bit and say something about both why this is happening, but I will start in a more, I think, political science, political philosophy corner, and address this question of what is illiberal democracy. Does it make sense as a term? Both Poland and Hungary have used this term illiberal democracy as a way to try to legitimize what they are doing. In particular, Orban has used this term. He loves this term. He's referring to it all the time. And they have also used the term constitutional identity to sort of legitimize the undermining of the rule of law and the rejection of the supremacy of EU law, as we have followed in recent weeks. So first, I will address this question: liberal democracy. What is that? What do we mean by it? And when we discuss this problem that we're facing right now. Normally, if you want to understand what they mean by what is in this term illiberal democracy, we have, of course, to make completely clear what is liberal democracy in an EU context, because obviously liberal democracy is also contested. But what is it we normally think about when we talk about entering into the EU and discuss liberal democracy in an EU context? So the claim that most EU law warriors, but also I think the court is making, is that when countries join the EU, they sign and accept it, this conception of liberal democracy, where principles and values embodied in Article 2 and also the acquis communautaire, all established case law, the treaties, legislation, and so on. And also this idea that the Union is founded on values and respect for human dignity, freedom, democracy, equality, etc. So it's very important, I think, to make this completely clear that this is what we are really talking about, and this is what it was challenged currently. Judicial independence have come up as something that is also targeted by Poland and Hungary at the moment, and there's been a broad discussion in Europe about whether judicial independence is something that the EU can actually demand that member states live up to. The Polish court argues constitutional tribunal has the Court of Justice and Strasbourg court's word that it's not a real court, argues that judicial independence is not something that the EU should be allowed to interfere into. But the question is whether you can even talk about upholding the rule of law in Europe if you do not have judicial independence. And that is certainly the claim that EU law warriors and also the court in Luxembourg, I think, will claim. You cannot uphold the working of the European legal order without having independent courts, because independent courts can then not challenge their own governments for not upholding directives and so on. And it's impossible, of course, to have a dialogue between national courts and the European Court of Justice, which is required to be a member of the EU. And as John made very clear, currently we're in a situation where judges in Poland, in particular, are prosecuted by this illegal disciplinary chamber in the Supreme Court for doing exactly that, referring cases, applying EU law, etc. So what actually happened? I think it's very important that even though we discuss this right now, as something that is going on in Poland, and I actually think that it was only when things exploded in Poland that we started discussing this in Denmark. But in Hungary, it's been going on, this undermining of the rule of law since 2010, when Orban came into power. I've described that in details in this book. Forced retirements, there are some tricks that are used both by Orban, but we see kind of a copy paste of that in Poland, of course, as John was also talking about. But it's not only forced retirement of judges that we have seen in both countries. It's also critical media that have been bought up by Orban's friends, oligarchs, so that in Hungary we have very, very few free media left, and those that ordinary people watch are definitely not free anymore. We are seeing the same kind of tendency in Poland, even though Poland is holding a bit behind on that aspect, but clearly inspired by what's been going on in Hungary. They have also both, but in particular in Hungary, because this has happened for a long time there, exploited the majority to change the constitution and electoral rules. This means that when we have a new election coming up in Hungary in 22, the spring of 22, it does seem that there is a coalition trying to challenge Viktor Orban currently, because all the opposition parties have assembled against Fidesz. But the problem is, of course, that when you have changed the districts for how you are elected and the rules of election in terms of who wins, who loses, it's very, very difficult to actually challenge the current state of affairs. And I'm still, quite skeptical about whether it will be possible, simply because of gerrymandering, changing of the basic rules for how an election is won. OEC actually already at the last election, general election in Hungary, did a report saying that that the elections had not been free and fair in Hungary. So we'll see. And the problem is, of course, that if you don't have independent courts, corruption can easily flourish. What is meant by this term illiberal, to be an illiberal nation? Orban says this: when I mentioned the European Union, I'm not doing this because I think it's impossible to build an illiberal nation state within the EU. I think it's possible. Our EU membership does not rule out this option. The question that I'm raising in my book and also in many other things I've written about this is that illiberal democracy simply doesn't make any sense. If you are an illiberal democracy, you're not a democracy. So you have this kind of fake democracy, and it's common that you then use not only constitutional identity references that you also find in the treaties, of course, but abuse them, and that you use this trick of not completely eliminating all rights, but you sort of use the law to curb the democracy in a particular country. It's the American professor Kimberly Shepard who have launched the term autocratic legalism, which means that you use the law to undermine the law. You use the law to undermine the constitution and the democracy, and you do it very gradually. So it's not something that is overturned by chance or jailing journalists and judges, but it's used as a small step-by-step mechanism where you constantly refer to the law to curb the law. And this is an incredibly dangerous tool to use because it makes it very, very hard for ordinary indices, those indices that we constantly use to monitor democracy all over the world. They cannot capture this kind of autocratic legalist capture. And here you see the democratic decline in the two countries we're talking about. And also here you can see that that Poland has actually had the steepest fall in democracy very, very recently. The question is, of course, will the internal market and the EU as such be able to survive this gradually erosion of the rule of law? I don't think and I think Henrik will talk more about that. But it's important to make completely clear that this is not just a fancy, interesting theoretical debate by some fanatic democracy fighters, rule of law warriors, or whatever. This is really about how do you uphold the rule of law, how do you uphold respect for the law, also when you do business in other European countries. We have already seen examples of courts in other European countries that will no longer hand over suspects to some countries in the EU, to Poland in particular. The Irish court, the Dutch court, and I think a German court also did the same. And that, of course, is a problem that just suggests where we are heading, where we are going right now in terms of upholding respect for basic principles of the internal market. So I think this is a really, really serious situation that we are facing right now. Okay, so what can the EU do? I think overall, I want to make the point that, well, I completely agree with John's point about the political will that is lacking. At the end of the day, what we are facing right now is really not a situation where we are lacking tools. It's a situation where there is no current political will to actually enforce or fight for these basic principles in the European Union. And I think it's very dangerous because the long-term consequences of this are much more dangerous than it seems that most politicians realize at the moment. So of course you have the infringement procedures that we all know. We have the rule of law framework and rule of law reports that had just been launched, I think 2 years ago, where all countries are evaluated every year, and that is a relatively new thing. Then you have the dialogue. You remember last week, or was it the week before, Angela Merkel said in Brussels, we should dialogue with the Poles, right? We have been doing that for more than 10 years with the Hungarians, and not much have come out of that. Then we have, of course, the Article 7 procedure, and currently we are seeing the EU refusing to hand over money from the budget, and then we have the rule of law mechanism that John was also talking about. So infringement cases, I'm not going to go into that, but generally just say that this idea coming out from a lot of heads of state and government that we'll leave it to the court to deal with this. At least that is the sense that I'm getting when I talk with experts and lawyers in Brussels and around Brussels and Luxembourg. It is that why do you always impose this on the judges, on the courts? Deal with this problem yourself, because every time there is an infringement case, it can only deal with a relatively small part of the problem. It's a restricted case. It deals with specific problems, and what is needed right now is to deal with the bigger problems, the bigger problem of what kind of union do we want? What kind of democracy should the EU be? So it really isn't a solution. And I think Merkel actually also said that you cannot just keep on having cases at the European Court. But the conclusion she did not make out of that was to say, okay, so we need to take on the task of solving these problems. She didn't do that. She said, let's talk some more, right? Then you have the rule of law framework that is very often used as a way of establishing a communication with a country that is considered to be in danger of undermining the rule of law. This has been done in both Poland and Hungary, and of course it leads up to using this article that is also not really going to be used ever, because it really is the bomb that never goes off, simply because there is a requirement for unanimity. in the end, not for starting the process, but in the end, you need unanimity, and there has been no willingness to use this tool by the heads of state and government, and I don't think we should expect that to happen. So there is some kind of feeling that we don't want to take away the voting power of these member states. We also cannot throw countries out of the EU, of course, and I also don't think there is any desire to throw anyone out. I really think we need to face that the challenges we have right now with Poland and Hungary are of a very different nature than the one we had with Brexit, where Brexit was a clean cut. It took a long time, but at least it was a relatively and legally speaking clean cut from the EU. We are now dealing with a situation where we actually have countries inside the Union that no longer respect basic democratic principles. And I think that can actually destroy the EU in the longer run if nothing is done about it. And I think this is something that is not realized by a lot of politicians who are still just talking about oh, we need to see what's happening in the longer run, and we should not push these countries away from us. And we might end up in a situation where these countries and citizens of these countries are turning their back on Europe. I don't think that analysis is correct. I don't think that polls, if you look at the opinion polls, 80% of the polls back the European Union project, and they do not want to leave. And in general, half of the population in Poland are supporting the EU, and also in the fight against peace on these topics that we are discussing right now. So I don't think that at all is on the agenda. I think it's rubbish to talk about Polexit. This is not where we are. This is not where we are heading. But we are facing a situation that is very, very dangerous because the EU, I don't think, can survive, and the internal market cannot survive if we don't have a respect for the rule of law and a respect for the European Court of Justice and its decisions. So I'm not going to say anything in details about this. The question is, however, still, because John did it so nicely, the question we still face right now with this new budgetary mechanism is, will it work? How will it be implemented? And when will we see the guidelines from the Commission? I agree with John that it's not even necessary to have these guidelines, but nevertheless, the Commission has argued that it will issue some guidelines for how to implement this mechanism, and it will not do so until it has the decision by the European Court in January, I think it will be, and therefore we need to wait and see what will eventually happen when the court rules on this topic. I also think that we need to be aware that we have some large countries in the EU, in particular Merkel. I don't know if she is going to hand over this problem to her predecessor, but we have to be completely clear about how Germany handled this question last year during the negotiations where the heads of state and government decided to issue this new rule of law mechanism. The Germans, who were in charge of the presidency of the EU, they actually tried to water down this mechanism. They tried to make it much less powerful than had been decided at the in the council meeting, the long council meeting, 4 days, I think it lasted in Brussels. Fortunately, the European Parliament said we cannot live with what the Germans have come up with, and then it was eventually a stronger mechanism. But we still don't know. How in detail it will be used by the Commission. Then you may ask me why and what is the problem with the Germans in this respect. And I think that we just have to realize that we have some big member states right now. We have France that is heading for a presidential election and therefore is lying very low in this debate. We haven't heard much from Macron on the rule of law lately. And we have a German chancellor who is, I wouldn't say afraid of her own shadow, but at least she does not like to address this problem in a serious way, in my opinion. And I think the interview brought in Politico in June by Merkel's best friend, or at least her most true ally, Wolfgang Schäuble, former finance minister, I think that summed up very nicely the problem that the Germans have in really forcefully addressing this question. And what did Schäuble say in this interview? He said, we Germans should not teach anyone about democracy. And I think that is, I was really dropping my coffee when I read this, because it really tells you that this is something that goes to the bones of this debate, that if the Germans still don't, and we may disagree or come up with an alternative explanation here, but if this is really the case, that you are still so burdened by what happened 50 years ago during the Second World War, that you are unable to address these challenges, I think we are in a very, very bad situation. And unfortunately, I don't think that Olaf Scholz will take it in a different direction. He might be pushed in a different direction by the Greens and the Liberals, of course. Finishing off, this is my last slide. I just want to say what our long-term problem with this. I think that the long-term danger of this problem that we're facing right now is that it may undermine the entire legitimacy of the whole European project. I think that we are very naive, and we will be very naive if we think that this question will not also influence ordinary citizens' feeling about what is this union, about what is this community, about what is this project about, if it's not about democracy. I think that if you look broadly out into the world, you see Europe surrounded by a rising China, Russia, maybe a new Trump in a few years, who knows, hope not on wood and so on, but I think that if the EU does not stand up for its own values, I think we are going to lose a whole generation of young people who are gradually, I think, coming to realize the added value of the EU, not just being a market, but also a community of values. The money that are handed out by the EU, that is our money, right? So we need to insist that, as Mark Rutte said, the EU is more than just a cash cow. It really is it builds on democratic values. And then just finally, how can the EU even act in the world without having, without insisting on the rule of law? I think that the EU is increasingly making a joke out of itself by promoting in its trade relations, in its aid initiatives in Africa, and its sort of criticism of China when it comes to Hong Kong, Taiwan. I mean, what will be the next? If we do not have our own house in order, how can we run around in the world and insist that everyone else should live up to human rights and the rule of law? I think this will be increasingly difficult. It will be the EU will be looked upon as a hypocritical institution, and I think that might be the end of the EU. I don't want to end on a very negative, critical note, but I just want to say that this is really, really serious. Thanks.
Thank you very much for highlighting that so much is at stake. We will now see where this goes. We'll move on to look at the single market as such. Our next speaker is a new kid on the block, at least in this building, Gorrissen Federspiel, because this is your first day at work here. But obviously you have sort of lots of experience from various other sort of positions. You were a consumer ombudsman. Most recently, you were Advocate General at the European Court of Justice. And I'm pretty sure that you must thank your parents for your middle name, because being called must be just as difficult as my name. I still remember when I was sort of introduced at COP16 in Cancun as, now we give the floor to Madam Lucky Fries. So now, ladies and gentlemen, I introduce you to Henrik Sausmann to speak on the importance of the rule of law for the functioning of the internal market. The floor is yours.
Thank you very much, Birgit, and I've been looking forward to start here today. I actually reintroduced my middle name when I became Advocate General because it doesn't work very well in French. That is the working language of the court. They tend to put out the U and leave the E. And the E, when they look at that, I think that's a computer mistake, so they delete that. That's why I reintroduced my middle name. I will speak to you today about the court's case law in this area, and that there's of course not very much, but there are some interesting judgments that might give us a clue of where we are heading. And I will also address the issue of why it is so important that we have an independent judiciary. When I prepared for this speech today, I didn't realize it before. I didn't realize why we are so dependent on independent judges. But I will show you with some examples that the judge in the member state where the problem is actually the judge who's going to decide. It's not other judges in other member states. So the whole European idea builds on that we can trust the judges, for example, in Poland. And this is not a new idea. In fact, if I can get this to work, I can just use it here then. No. Now, if we go back 3,000 years, we find an interesting quotation from Plato, saying where the law is subject to some other authority or has none of its own, the collapse of the state, in my view, is not far off. But if the law is the master of government and the government is its slave, then the situation is full of promise, and men enjoy all the blessings that the gods shower on the state. That's pretty precise 2,000 years ago. And our socialists wanted to add that it is more proper that the law should govern than any one of its citizens. And if we look at some of the more recent, the Roman Republic, Cicero said that we are all servants of the law in order to be free. In fact, it was in the UK, in the Constitution of Magna Carta, we first find traces of the rule of law. And interesting, the House of Commons said to King James I of England in 1610 that the most precious things that the king has given his subjects were actually the rule of law. And then, of course, we have Montesquieu, who taught us in the 1700s that the importance of the separation of powers. So this is not a new idea. Let me give you an example to put focus on what is at stake. Imagine, and we turn away from Poland for a minute. Imagine that we have a change of government in Belgium. There are a new Belgian government in place. They are extreme anti-immigrant. It could be the Vlaamse Partij, who has an absolute majority. They want to get rid of some of the Polish workers in Belgium, or at least reduce the numbers. How do they do that? They lower the salary by 25%. What should a Polish worker do about this? Can you go to a Polish judge about it? No. You can't
get any help in Poland because they don't have jurisdiction. Can he go to the Court of Justice in Luxembourg? No, there is no remedy enabling an individual, a person, to challenge a Belgian law in front of the European Court in Luxembourg, because there's no what the lawyers can actually popularize. He is completely dependent that a Belgian judge will rule on it and declare it discriminatory against the government in Belgium, put in place by the majority of the people. And that is precisely what we are talking about now, is that we are dependent on the Belgian judges in this case. That he will rule that is clearly discriminatory, or if he had any doubt, I don't think that there's doubt here in this example, he could refer it to Luxembourg and get a ruling, because it's a dialogue between judges. We should not forget that. This example is actually used to convince the Polish minister of the importance of the independence of the judiciary, and as far as I know, it was actually understood by the Polish. One of the first examples we have is Ireland, the High Court in Ireland. I had a similar case from the Supreme Court, but this came first because it was an expedite ruling. Could you extradite a person, this was a Polish citizen, that was wanted in Poland for trial if there is an Article 7 procedure against Poland and there's a risk that he will not have a fair trial in Poland? That was a serious question. So that was on a general base, and the court came with an answer saying you have to look into concrete circumstances and evaluate High Court whether you can actually extradite him. So there was no automatic extradition of this person to Poland. Afterwards, the High Court in Ireland said that there was no reason to believe that he would not have a fair trial in Poland, so he was extradited. The effective judicial protection is a notion that has been developed in case law and is now in the Charter of Fundamental Rights. The first one was the Johnson case. It's a very famous case about a female police officer in Northern Ireland who were not able to bear firearms. And you had to bear firearms at that time because the situation was very tense. And so she could not have her job. This was the first time that the court said that the effective judicial protection is a fundamental right in the EU. It was repeated in Highlands and Cardi. Cardi is interesting because Cardi was somebody who was supposed to be connected with Osama bin Laden, and his assets were frozen in the EU after a UN security resolution. But what did the court say? Even he has fundamental rights. So he was not heard, and they annulled the decision of seizing his assets because of an effective judicial protection. Now, the court has always said that how you administer your court in your member states is up to the member state, but there are some requirements and some red lines, as our president has said recently in Hague. And the red lines are that the remedy should satisfy the principle of equivalence and minimum effectiveness. So if you have rights, EU rights, you should have effective remedies to challenge them before a judge. And that's very important. We have a union based on the rule of law. It was said very clearly in Lever and has repeated afterwards. And it's now in the Charter of Fundamental Rights in Article 47. So it's in all areas covered by union law. Now, I had the privilege of being actually the first Advocate General to deal with this whole aspect, because the Portuguese judge's judgment came first. And the question here was, could Portugal, I think I said Poland, I meant Portugal. Could Portugal lower the salary of judges in Portugal to have a better budget after the euro crisis? To lower the quality. They did not only lower the salary of the judges, there was a whole public administration from the president all the way down to the lowest civil servant. And the question was whether you could actually merged the requirements in the Charter in Article 47 into Article 19 of the treaty. I said it is probably not possible, but the Charter is applicable, but the judges' independence will not stay. Well, at the end result, the court agreed with me, but they made a merge, and it's a very important merge. It is actually what my Dutch former colleague, Sascha Prechal, has said in an article to be published soon. It's a game changer. And I agree with her. Because what the court says very precisely here is that national courts and ECJ jointly ensure correct interpretation and applicability of EU law. So it's not just for the Luxembourgish court, it is primarily for national court to ensure that our rights are protected. And the court said, which I agree, of course, that independence and impartiality is inherent in the task of adjudication. So what was said in the Charter actually applies throughout the treaties. And here I come to a point that you made, John. You cannot be independent in one situation and not independent in another situation. So if you, a national judge, have the competence at some point to deal with EU rights, you have to be independent. And you need, of course, also to be independent in purely national procedures. There's been a further development in Republica. The court has said that member state must refrain from diluting or making of any regression in the laws on the organization of justice, and they may not adopt rules that undermine the independence of the judiciary. That is pretty clear. And I took out two cases, Subaru and Deutsche Umwelthilfe, that really shows how far they go in case law. In the first one is a Hungarian case, and the frustration from the Hungarian judge who referred the case to the court in Luxembourg was that he told repeatedly that an asylum seeker had the right to have international protection in Hungary. But it went back to the administration and they denied international protection. So the case came back to the judge again, and he said in frustration, what should I do? And the court told him to sue, but if it keeps coming back to you and you're not on the same ground, you make the decision that you grant, even though you don't have competence to do it under national law, you must do it now and give international protection, even though the Hungarian administration is not willing to do so. It's quite an important judgment. I had Deutsche Umwelthilfe, so it's not only about Hungary here. This is a German case, as you probably have guessed. Markus Söder said publicly that he would not ban diesel cars in Munich. No question. Bavaria is the country of the cars, and people can drive wherever they want, and they can also drive into the city center of Munich. The problem here was that the pollution in Munich is way too high according to the directive. And the Deutsche Umwelthilfe tried repeatedly to get a ban on diesel cars, at least for some hours in Munich, and they said no. And they had to pay fines, but it was from one public case first to another public first. So it was ineffective. What was the question? The question was, should we go so far as to put Markus Söder in prison until he complies? And you laugh, and I said, I had the case that, of course not. Of course not.
That could have changed German politics.
That could have changed politics. And when I came out with my opinion, I think that was just before he was announcing that he would probably candidate to the council. But the court said, if you look at my opinion, and the court says, if you have the legal base in German law, you should use it to enforce EU rights. It's pretty impressive. Now, I will not go through all these judgments, don't worry. It's just some of them concerning Poland. But I will mention a couple of them. The most recent cases, the judgment in Poland, and an interesting thing is here, it's a mixture of infringement cases and preliminary rulings. Remember, so the Commission has taken some cases, but others have been referred by Polish judges where they think that their colleagues are not independent. In fact, the most impressive is the one still pending where we have the opinion of Bobek, the C-132. That's a judge asking whether judges in the lower courts are independent because they were put in court during the communist regime, so they cannot be independent because they swore allegiance to socialist state of Poland. But the judge who is referring is himself questioned in another case because the board who appointed him has been challenged by the Constitutional Court in Poland. So his own position is taking another pending case. And the Constitutional Court in Poland has been said by the European Court in Strasbourg that it's not a court according to Article 6 because it has members that has been illegally appointed. So you can really see that it is increasingly a mess and a big problem. And we have, of course, the order from the vice president, the Danish vice president recently ordering Poland to pay 1 million euros per day until they comply with the criminal measures taken by his predecessor. And I think that the most important problem is, of course, that you can risk disciplinary sanctions if you ask questions to the court or if you have if you apply the case for the court in your cases. The court has recently ruled in the Consorzio Italian Management that the CILFID criteria, the criteria that applies if you are the last resort court and you have a doubt, you have an obligation to ask. Bobek proposed a more lenient regime on that, but the court actually basically stuck with CILFID 1. So CILFID 2 is basically the same. So if you are the last court, national court in a case, you have to refer unless you are completely sure of the interpretation. And an interesting thing is that in the pending case, my former Irish colleague, Hogan, has asked that it should be easier to get compensation if the judgments are wrong. If a national judgment is wrong because you did not ask a question or you applied the EU rules wrongly, it should be easier in the future to get compensation from, in this case, the Polish state, if the Polish judges are not independent. Who should rule on that? Or the Polish judges. So you can see the problem here. Now I come to the internal market. Many of these cases come up as cases against the judge's own member state. And it can have significant political and economic consequences. I'll give you a few examples, and it's from different countries. I have been advocate generals in some of them. In New Weimar case, a Belgian judge asked whether it was legal to have a requirement to write all invoices in Flemish, even though you were dealing with Italians. They don't understand Flemish, so they wrote the invoice in Italian. But there's a public law order that you should write it in Flemish. And that was a Belgian judge who asked, and you know just a little about the language struggle in Belgium. I think that's a highly political issue. But of course, the question was asked. And we ruled, not surprisingly, that this a bit bizarre rule was contrary to the pre-legal approach. In Herzberg, it was a German case. The question was whether the employees who can have the right to vote half of the member of supervisory boards of the mother company, Germany, is only for workers in Germany or also in the TUI, it was TUI, the company, the travel agency, whether it also applies to people working in Greece or France or elsewhere in Europe. That put at stake the Wirtschaftswunder, the Mitbestimmungsgesetz in Germany, because if you allowed that, you would not be able to keep that rule that the employees have half of the seats in a supervisory board. The Erzberger was a question very, very important. The Altum was a very, very important case from Belgium, following one from France, where the migrant workers who come with certificates saying that they are affiliated in the home countries, typically from Eastern Europe, can you set that aside if you think it is fraud? Again, there's a lot of money at stake here, and the judge has to go sometimes against the will of its own government. The Sego was a Hungarian case. Hungary didn't allow people to buy land when it was a communist regime, but you could have rights to use agricultural land. But before they became member of the EU, before the transitional period, they deleted all the rights, unless you had family connections with the owner of the land. Then everything was deleted. And that also was contrary to not only article on the free movement of capital, but also the Charter, Article 17 on the protection of property. Again here, a very, very courageous Hungarian judge asked a question. And I could go on. I think I'll drop to the last two ones and say the state aid cases. Think about that for a minute. The state decides to give legal aid to a company, and a judge has to say, no, it's contrary to EU law, you have to repay everything. Or public procurement. We've heard that there are some problems with public procurement, apparently, in some of these countries. What does a company do who are not allowed to participate or was excluded from the procedure? They have to go to the local judge. If we look at, and of course, getting increasingly closer to my current job as a lawyer, what happens if you are a company, a Danish company, for example, dealing with a Polish company? Should you avoid jurisdiction in Poland? When do we have jurisdiction in Poland? Well, if we deliver goods, or the goods should be delivered in Poland, or if the services are to be provided in Poland, if you sell to the Polish consumers, if it's a tort case and the damage occurs in Poland, if it's about real estate in Poland, if it's about individual contracts of employment, you have employed Polish workers in Poland, or you have a branch in Poland and you do business out of that. All of these cases, you have jurisdiction in Poland. And you risk of having a Polish judgment that can be enforced in Denmark. That's the problem. Because the Brussels 1bis regulation has what we call free movement of judgments. So only in a situation where you could argue before the Danish judge that this Polish judgment, now to be enforced in Denmark, has been handed down by a judiciary that is not independent. And you could argue a case on Article 45 of the regulation saying that it's against manifestly contrary to public policy. We have no case law on that. Then you could hinder an enforcement of the Polish judgment in Denmark. I looked everywhere to see if we could find anything that comes close to whether we could actually have this argument before a Danish judge. And the closest I could find is the case in Hungary against Parliament, because Parliament decided to ask for initiation of an Article 7 procedure against Hungary, sorry. And Hungary challenged that. And the question, one of the main questions was, does it have legal effects that Parliament asked the Council to initiate an Article 7 procedure? Yes, it does. Hungarians can now seek asylum in other member states. That's the legal consequences of an Article 7 procedure. Hungary is considered a safe country, but now, no, it's not anymore safe as in asylum rules. You can actually, according to a protocol of this judgment, if you're Hungarian, you can seek asylum in Austria. Should the companies avoid jurisdiction? Well, that depends on the circumstances. And here, of course, it's obvious to tell you to seek legal advice before you do anything.
Look further.
Could you agree on a jurisdiction outside Poland? According to Article 25, yes, you can. You should have jurisdiction in a neutral place, Sweden or Germany. We've seen examples of that. Could you have arbitration? That's a good question. It's a good question. The first two cases I mentioned here say that you are not, that member state could not enter into arbitration clauses based on a more general scheme. The first case, Acmea, was an investment bilateral agreement between member states. And it was said by the court in Luxembourg that such a scheme undermines the preliminary ruling procedures, so it cannot be upheld. But you can still, as private parties, have arbitration clauses. We think between private parties, yes. Could you have it between a private party and a member state in an ad hoc case? Well, that is an interesting issue if you look at the last one, Poland versus PL Holdings, because what the court says here is that if you try to circumvent the ban on member state going into arbitration clauses, you could have a problem. So we need to analyze that judgment very carefully, but my interpretation of it is that it is still possible, and it's something that should be at least considered to avoid problems of if we go further down this path of problems of independence of the judiciary. But you can see that it is not just a political issue, it is a very commercial issue as well. It is the whole foundation of the internal market that could come at stake if we continue down this path. Thank you very much.
Brilliant debut, Henrik. I'm sure that you are allowed to stay a couple of more weeks here. Our time has basically gone out, but do we have here in the room one or two questions? I'll allow for that. Yes, here.
Thank you very much for very interesting speeches. I just list one thing. What is your specific and operational suggestion for what to do?
Just wait. Do I see another question? Yes, gentlemen here.
I just wanted to ask also, what is the perspective related to enlargement? I mean, what do we learn from new member states coming in, changing their constitution, and therefore undermining the judiciary? Should we expand on the Copenhagen criteria to make more explicit these issues that we have discussed here today?
Yeah, very easy. What do we do about enlargement, and what do we do sort of specifically when we have a problem?
Enlargement, I think I will leave to my two colleagues. But on the first questions, that really depends on what we're talking about. Are you about to invest in Poland? Are you going to build a factory there? Are you selling goods to Poland? What is an issue? Because I think, as far as I've understood, we are heading against a possible mess. But we're not there yet. Now, we should not forget a lot of judges who still ask questions, who still apply for European law. So we should just be aware, if it's long-term investments, we should probably think a little bit ahead. And again, I think the best answer is to seek legal advice before you make a big investment. How do you protect that investment?
Thank you for that question. Of course, an unexpected question. So if the problem is political will, then the solution is political will too. One of the things that is striking to me when I talk, I often do, for example, the Dutch parliament, is that they don't cooperate with other parliaments. I think that's a horizon that should be explored much more. It's much better to put pressure on your respective governments together than working in isolation. I also think that it should be a really serious option to think about using the interstate complaint system. It is possible for Denmark to sue Poland directly if the European Commission refuses to do so. I mean, of course, that's not a very attractive option. In the Netherlands, parliamentary questions have been asked about this, and the Dutch foreign minister said, I don't rule it out, but I prefer to do it together with at least one other member state. Denmark and the Netherlands together make two, so perhaps there should be discussions there. I think that you should not underestimate if you seriously openly consider using such hard law options. It will also change the dynamic, because not many people realize, and I know that because I've worked as a diplomat myself, there's a lot of politicians who talk strong language politically, maybe in their own media, but they don't open their mouth in any council meetings. There's actually very few member states that actually do speak up. That's why it was remarkable when I was 4 weeks ago in the European Court of Justice, that all member states, including Denmark, actually used extremely strong language. So you can simply ask, as a journalist, if there's anyone here, can you promise that you actually speak up in that way in a political setting too? Will you send a diplomat from the Danish embassy in Warsaw to monitor one of the trials that I showed you earlier? There's a lot of things that you can do. It can vary from hard law to symbolic, financing NGOs. There's many things you can do to keep up the pressure, and that's why my answer is create political will. Yeah.
Yes, thank you very much. Actually, you were the one who wrote a PhD on enlargement. So
I'm the chair.
You should be the one answering. I actually some time ago wrote a column in Berlingske Tidende called "The Tyranny of the Small," and I think your question is the small countries in the EU. I think your question is really well put, because this is not just a substantial question about small countries that are not fit for true membership because they have undermined the rule of law, no independence of the courts, and so on. But it's also about, think about it, I mean, that you all of a sudden have countries, very small countries, with one vote in the council, making it even more difficult to change very much, or to uphold a little, I mean, if in particular, if democracy is undermined in those countries. So my personal view is certainly that in order to make sure this will not happen, that we make sure that new small countries in the Balkans are fit to enter before their last phase. So that's my personal view.
Excellent. And then basically sort of we went full circle going back to the Copenhagen criteria. So thank you very much to our panelists. We'll put all the slideshows on our website. We'll also put a report on the website. There'll be plenty of things that we have to follow up upon here. I think it was mentioned that on the 23rd of November, there'll be another sort of verdict coming from the European Court of Justice concerning Hungary. We will also obviously wait exactly what will happen with the new German government. The Ampel coalition, will they have a different attitude than the Merkel coalition? Personally, I doubt it. So that's going to be interesting to watch. But we'll follow up on that, and we'll do that specifically on the 29th of November, where we have our next conference. This will not be here, but with our other neighbor over there, so the Confederation of Danish Industries, where we'll basically start the countdown to the EU presidency of France, but obviously also French presidential election. So thank you very much for coming, to all of you following us, and to all of you being here. Thank you very much.